opening statement. My colleagues, the purpose of today's business meeting is to authorize the issue of a subpoena to OMB for documents relating to the DOE loan guarantee to Solyndra Incorporated. This is the first time this committee has considered a resolution authorizing a subpoena in this Congress. On March 14, 2011, this committee requested documents from OMB relating to Solyndra's loan guarantee. Specifically, the committee asked OMB to produce all documents in its possession relating to Solyndra, such as internal reports or analyses, and all communications relating to the deal. 3 months passed. Committee staff worked extensively with OMB staff to obtain production of the documents and to offer accommodation, such as in-camera reviews, but we still could not get production of the documents. The internal communications and documents we requested were not produced. Realizing we were getting nowhere with OMB, this subcommittee scheduled a hearing for June 24th, invited the OMB Deputy Director Zentz to testify so that we could get some information about OMB's role in the DOE loan guarantee process. He did not show. At that time, we talked with Ranking Member DeGette and Mr. Waxman about the problems we were having obtaining documents from OMB. Ranking Members DeGette and Mr. Waxman asked us to identify categories of documents for OMB to produce and offered to contact OMB to see if they would agree to produce these documents that we needed. We took them up on their offer and listed 4 specific categories of documents for OMB to produce. In response, OMB offered to allow staff to review but not take possession of only one of the 4 categories: OMB's emails with DOE about the Solyndra guarantee. That viewing took place took place this week. But even that production did not include all the responsive documents in that one category, as OMB stated it was still gathering its communications with DOE from 2010 and 2011 when DOE modified the terms of the Solyndra deal. The most important information in the documents, the risk ratings assigned to the Solyndra guarantee, were redacted. Committee asked OMB staff again about the other categories of documents the committee had requested and whether OMB would produce them. As was done repeatedly over the last 4 months, OMB refused to respond. I can only conclude that after 4 months and extensive efforts to obtain these documents, that OMB does not intend to produce them voluntarily. This committee has established its need for this information. The DOE loan guarantee program is within this committee's jurisdiction. The program has issued $11 billion in financing. The first recipient of a loan guarantee, Solyndra, experienced financial setbacks which caused DOE to modify the loan. It also raised a question about whether DOE and OMB were doing a thorough job of vetting these deals and mitigating the risk to the taxpayers. Furthermore, the committee had not conducted any oversight of this program in the previous Congress. So, my colleagues, it's time to take a look and see if this program is working. I understand my colleague, Ranking Member Waxman, has called this subpoena an abuse of the subpoena authority, end quote, and claims that OMB has been working in good faith with the committee. I respectfully disagree. Voting to authorize this subpoena is a necessary step in carrying out this committee's constitutional obligations. We simply cannot allow executive branch agencies to pick and choose what they will produce or whether they will produce it at all. We are the stewards of the taxpayers' money, and we need to ensure that the billions of dollars appropriated for the DOE loan guarantee program are properly invested. Before I close, I'd like to seek unanimous consent to enter into the record a letter from Solyndra sent to me and Ranking Member DeGette yesterday. Without objection, so order. This letter outlines Solyndra's current revenue and sales. I'm happy to put this in the record. We have no desire to cast aspersions on an American company that is trying to create jobs in this very difficult economy. But we do need to find out what OMB did with regard to Solyndra's loan guarantee. If OMB has nothing to hide, they should have turned the documents over 4 months ago, and perhaps we would have been done with this investigation by now. Hopefully, if OMB turns over the documents this committee is seeking, there will come a point in time when the committee can have a full examination of the facts on the record about the job OMB and DOE did to assess the financial conditions of this company and whether they took the appropriate steps to assess and mitigate the risks presented by this guarantee. I now recognize my good friend from Colorado, the ranking member, Ms. DeGette, for her opening statement.
Thank you very much, Mr. Chairman. Well, I was pleased to hear you say that you don't have any desire to cast aspersions on an American company. And I also agree with the chairman that this loan guarantee program is a legitimate subject of the subcommittee oversight. And I also agree, as I've told the chairman, that the committee has broad rights to the documents regarding this loan. Where I've got a problem is, from anything that I've seen, the OMB and the administration have been trying assiduously to comply with what have been a series of broad and vague document requests. And I do take a little bit of umbrage at some of the characterizations of what documents have been provided or not. I think we should get the documents. But from what I know, OMB has really been trying to comply with this. So let me just spend a few minutes going through exactly what has happened here. On March 14th, this committee sent a letter to OMB requesting documents related to the Solyndra loan guarantee. And that letter on March 14th, Mr. Chairman, did not delineate these four categories that you're talking about today. In fact, I'd like to enter in to the record a copy of that letter, as well as a copy of the letter that you sent to Jack Lew yesterday, July 13th, as well as a copy of the executive branch's response on July 14th.
Without objection, so ordered.
Thank you. Because in that original document, it was a much broader set of documents that were requested. And after that, all of the committee staffers, majority and minority, started working with the OMB to try to get some kind of a production of documents. The initial response was provided on March 31st. The first production of documents was on April 4th. There was a committee briefing by OMB on April 11th. On April 15th, OMB responded to follow-up questions from that April 11th briefing. On April 25th, OMB provided additional information and also answers to questions. On April 27th, there was an in-camera review providing committee staff to review cash flow information. On June 7th, OMB held an additional in-camera review of documents. On June 20th, OMB Director Jeff Zients was supposed to testify, but he couldn't come, and we haven't had him back. Then during another July 11th in-camera review, OMB produced 1,400 pages of documents and offered to conduct additional searches of the internal emails. And after the July 11th in-camera review, OMB offered up further briefings and reviews. So I think a fairer characterization of the events is that OMB is trying to comply. Whether the committee thinks they're complying or not is a different issue. Now, Mr. Chairman, I was a litigator for 15 years before I came to Congress, and I spent many hours in judges' chambers arguing about discovery disputes, which is exactly what this seems to me to be. And so what I always found when I was practicing law, the easiest way to resolve a discovery dispute like this is to lay out specific categories of documents and to arrange for them to be produced. If that doesn't happen, then a subpoena would be the appropriate way to go. But when, in this case, as I think the agency really has been trying to act in good faith, I think we should still continue to try to clarify the request and get those documents in, because you are absolutely right. They have the responsibility to produce the documents, and we need to have a full disclosure so that we can have our hearing. But I think, and I'm glad to hear you say that you don't intend this for political purposes, because it sure smells like that to me, and I'll yield back.
Thank you, gentlelady. And now we recognize the distinguished chairman of the full committee, Mr. Upton.
Well, thank you, Mr. Chairman. Today's business meeting is to authorize the issuance of a subpoena. It's a first for this committee in this Congress. The resolution will authorize me to issue a subpoena to the Office of Management and Budget, OMB, for documents relating to the DOE loan guarantee for Solyndra. This is not a step that our committee takes lightly. As many of you know, I was once employed at OMB during the Reagan administration, and I am certainly very sensitive to the agency's concerns and its roles in the executive branch. But this committee and this Congress is a co-equal branch of government. It does have an institutional obligation to obtain information from the executive branch so that it can carry out its duties. And the program that we are investigating, the DOE Loan Guarantee Program, falls squarely within this committee's jurisdiction. The program has so far issued over $11 billion in financing for loan guarantees. And Solyndra, the recipient of the first guarantee, has faced some financial challenges. DOE was forced last March to modify the terms of the Solyndra deal, further raising concerns about whether it was an appropriate use of taxpayer dollars. This committee has never conducted oversight over the loan guarantee program before, but yes, it is our responsibility to do so. I would think that all of us would have hoped that we would not need to exercise this subcommittee hearing today, issuing the subpoena authority, but our patience finally has worn thin after many months, and I support Chairman Stern's resolution to require that the documentation be turned over to the subcommittee, and I yield back.
Thank you, gentlemen. And now I recognize the full committee ranking member, the distinguished member from California, Mr. Waxman, for 3 minutes.
Thank you, Mr. Chairman. I agree with everything the chairman of the full committee had to say except his conclusion. I do not support the subcommittee issuing a subpoena at this juncture. The resolution before us is rash, premature, and does not reflect responsible use of the subpoena power. I've repeatedly stated that the committee is well within its rights to investigate this program and the role that OMB plays in it. And if OMB does not cooperate with the committee, I would be supportive of a subpoena. But OMB has been cooperative. They have provided thousands of pages of documents to the committee and said they are willing to provide additional documents. All they have asked is that the committee explain why the committee needs to see OMB's internal emails so OMB can evaluate the committee's need for the documents against OMB's legitimate interest in confidentiality and make an informed judgment about how to respond to the committee. The problem is that the committee majority has not met this basic burden. Their position is that the committee is entitled to go on a fishing expedition through OMB's internal documents with no showing of need. That's not how we should proceed. OMB has shown the committee thousands of pages of documents. The committee has seen every communication OMB had with the Department of Energy and every communication that OMB had with Solyndra, the applicant for the loan guarantee. We have reviewed these documents, and our interpretation is that they show that OMB was doing its job. OMB raised important questions about the loan guarantee and acted to protect the taxpayers' interest. We have shared our assessment with the Republicans and asked them whether they believe the documents we have received raise any concerns. We've also asked whether they have any other evidence of wrongdoing or impropriety by OMB. We've received no answer. The majority has not identified any document or evidence that raises any concerns about OMB's actions. That's why I think this subpoena is premature. Before we force OMB to produce sensitive internal documents, we need a good reason, and one has not been identified. One issue the majority has raised is whether there was any political pressure on OMB. I would be concerned if this were the case, but we have seen zero evidence of this. Moreover, OMB has said that if this is the concern, OMB would consider responding to a document request tailored to produce information related to any potential political interference, and the majority has refused to pursue this overture. Instead, the Republican position is that we don't have to articulate a reason to see the documents. We don't have to produce any evidence of possible wrongdoing. If we want to go on a broad, open-ended fishing expedition, we're entitled to do so. I fundamentally disagree with that premise. This is not the first time I have been part of an investigation involving OMB, although I've never been involved in an investigation with OMB when Fred Upton worked at OMB. But when I was chairman of the Oversight Committee in 2008, we investigated the role of OMB in the revision of clean air standards. We ultimately issued a subpoena, but the circumstances then were different than those today. In 2008, we had clear evidence of the Bush OMB acting contrary to Clean Air Act requirements, and the Bush administration OMB did not cooperate with our committee. Today's circumstances are different. There's no evidence of OMB impropriety, and the Obama OMB has been attempting to meet the committee's needs. The subpoena power is one that should be used with restraint and as a last resort. The committee should not act like a bully just because it has the power to do so. My hope is that with a renewed effort, the document disputes can be resolved to the satisfaction of both the subcommittee and OMB. I do not support a decision to issue a subpoena at this time. I respectfully request that the subcommittee reconsider its approach and that we not take this very drastic kind of action of issuing a subpoena, and that we consider trying to get the information through negotiation with OMB. And only if that fails, and we've identified what we want, and if we're not being given that information, would I join in support of the subpoena.
I thank the gentleman. I recognize the full committee chairman emeritus, Mr. Barton from Texas, for 3 minutes.
Thank you, Mr. Chairman. I listened with interest to what my good friend from California just said. I was in his position the last 2 Congresses, and prior to that was in the position that Chairman Upton is now. I agree that the subpoena authority of the Congress is one of its most important authorities. I agree that it should be sparingly, and I agree that it should only be used as a last resort. I would differ from my friend from California's analysis that this is not a last resort. This is a loan program that was authorized by this committee when I was chairman under the Energy Policy Act of 2005. When Chairman Upton became chairman in this Congress, at the beginning of the Congress, requested documents from OMB and the Department of Energy. The final response to that document request was a series of almost one-sentence emails that in totality, I believe there were 8 emails. 8. Now, Chairman Waxman seems to say that, well, if you're not alleging wrongdoing, the Congress doesn't have the right to the information. If they're not hiding anything, why in the name of common sense don't they voluntarily comply? We've had staff briefings on a bipartisan basis. The staffs have agreed to look at some of these documents if provided in camera. The majority staff and subcommittee chairman and full committee chairman have been over backwards, and they've been met with almost disdain and arrogance. Well, the Congress of the United States has the right to know. The House of Representatives is the most direct repository of the people. We're elected every 2 years. We represent the people. We are the people's house. The Office of Management and Budget, the Department of Energy, unless they claim executive privilege, which they're not claiming, have absolutely no reason to not comply voluntarily with this subcommittee and full committee's document request, and they are absolutely stonewalling us. If Chairman Waxman, as his right as the minority, does not wish to support a voluntary compliance, if he doesn't wish to support the vote for the subpoena, he has the right to do that, but the majority also has the right to force the issue and to issue the subpoena. This is the first subpoena that Chairman Upton and Subcommittee Chairman Stearns have requested. We're in the 7th month of the new Congress. I think that is an admirable record of restraint, but in this case, enough is enough, Mr. Chairman. I fully support the subpoena request, and I will support its enforcement if the majority of this subcommittee votes to do it. With that, I yield back.
I thank the distinguished member. Recognize the full committee chairman emeritus, Mr. Dingell from Michigan, for 3 minutes.
Mr. Chairman, I thank you for your courtesy. I find myself very much regretting the situation we have here before us today. We're debating whether or not to issue the committee's first subpoena this Congress. I will be happy to support a subpoena if such is necessary for the conduct of the business of this committee, and I'm willing to give the broadest of latitude to the chairman of the subcommittee and the full committee on this matter, and I'm certainly anxious to support the prerogatives of the Congress. This is an important responsibility, oversight, and as my colleagues will remember, I have always been a vigorous practitioner of that. But I would note that in many instances where we were addressing this, we would look to see whether in fact or not there was a need for a subpoena. It's my understanding that all of the information requested has been forthcoming from the administration. If not, I'm willing to hear that it has not been made available and will not be made available. That being so, perhaps maybe a subpoena is in order. But I don't believe the case as of this particular minute has been made that the administration is in fact stonewalling on something essential to the business of the committee. And if we are going to get something that we are being denied, and subpoena is the way to get it, I will be supportive. But as of this particular minute, I am not seeing those signs, or that is the way that this subcommittee or this committee must proceed on these matters. I understand that OMB has cooperated with the requests of the committee, providing thousands of documents, hosting multiple briefings, and allowing interviews of relevant individuals. I've heard no information that anybody has been denied the access to interview individuals or to achieve the cooperation of the executive branch. Every effort should be made, it's always been my view, to reach an accommodation with OMB before we take this step. We have always done so in this committee, and I have to say that I do not believe here that all avenues for cooperation have been exhausted. Therefore, I believe the issuance of this subpoena is going to be premature, and that's one of the reasons I can't support it. If a case is made that there has been stonewalling and lack of cooperation, which I have not yet seen, perhaps I will have reason to change my view. But that has not yet been placed before us, and so until it is, I have to say I can't support the subpoena, even though I will support it if the case is made that there is stonewalling here and lack of cooperation with the administration. I yield back the balance of
I thank the distinguished emeritus. At this point, any member can be recognized for 1 minute for an opening statement. Does anyone on our side? Mr. Gingrey is recognized for 1 minute.
Well, Mr. Chairman, I want to thank you for calling today's business meeting on accessing information regarding the Department of Energy's loan guarantee program. After nearly 4 months of efforts to obtain information from OMB, the administration has yet to fully cooperate with our efforts, and this resolution is necessary to help us get those answers. And I am convinced that we have made these efforts and they have not responded. One of the most important aspects of our role as a watchdog over taxpayer dollars is the ability to conduct oversight on various executive agency programs. The Department of Energy Loan Guarantee, it's an $11 billion program, and it is in the best interest of the American people to ensure this money is being spent appropriately. Unfortunately, instead of assisting us in this manner, OMB has obstructed this committee's ability to do its work. Therefore, Mr. Chairman, I believe that we are bound by our constitutional duties to obtain information from OMB, and unfortunately, due to a lack of assistance from the administration, we're being forced to issue, regretfully but appropriately, this subpoena. In order for this committee to properly conduct its oversight duties, I urge my colleagues to support this resolution. And I yield back.
I thank the gentleman. Is there anyone on this side? Mr. Green is recognized for 1 minute.
Thank you, Mr. Chairman. And like our colleagues on this side of the aisle, I'm disappointed we're here today. I completely support the objectives of providing rigorous oversight of the executive branch, and it's certainly appropriate to hold them responsible for their actions and expect that they comply with the request of Congress and this subcommittee. The House of Representatives, through our committee, has the right and the obligation to receive any information on this program. However, it's my opinion that the action we're discussing during this proceeding is both premature and unnecessary. A subpoena is a very serious step, and I believe it should be used as a last resort. I prefer this subcommittee pursue a more measured approach, discovering the facts surrounding the loan guarantee. The issues that you and your colleagues in the majority have raised are troubling, but it's true that there have been no hard facts, only speculation that created these allegations. For this reason, I don't believe the subpoena is a correct tool to use to initiate the problem and without any cause for doing so. I take the function of our subcommittee seriously, and our full committee, I believe subpoenas are an important tool in our quiver, but to providing oversight, but I don't believe that in this instance it's necessary, and so I intend to oppose the subpoena.
Thank you, gentlemen. Mr. Sullivan is recognized for 3 minutes.
Thank you,
1
Chairman
minute.
Stearns.
Sorry, 1 minute.
Thank you, Chairman Stearns. Thank you for calling this business meeting today to consider a motion authorizing a subpoena for OMB records relating to the DOE stimulus loan guarantee to Solyndra, Inc. 4 months ago, this committee requested documents from OMB relating to its role in the review of a $535 million DOE loan guarantee to Solyndra. Despite good faith efforts, OMB continues to withhold documents, and in fact, an OMB official skipped a hearing on our Solyndra investigation just a few weeks ago. What are they hiding from the American people? Under the stimulus, the DOE loan guarantee program authorized $11 billion in financing, and the first recipient of that financing was Solyndra, which has suffered financial problems resulting in DOE's modifying the loan. Determining what actions OMB and DOE took with respect to Solyndra loan guarantee falls well within this committee's jurisdiction and constitutional interest. Americans deserve to know their taxpayer dollars are being spent wisely. As a longtime critic of the Solyndra loan guarantee, I will vote in favor of this subpoena to ensure that the Obama administration stops thwarting this committee's investigation into this important matter, and I yield back the balance of my time.
Gentleman yields back. Anyone on this side of the aisle request 1 minute? If not, anyone? Mr. Terry is recognized for 1 minute.
Thank you, Mr. Chairman. I frankly feel that this is an obvious decision with the stonewalling and frustration that's been caused by OMB. We've asked for 4 categories of documents. OMB has partially provided or answered our request for documents under 1 category. It was in camera, partial documents, not all of them, and redaction. Oh, I mean, what level of arrogance in redacting the information to the Oversight Committee? So there's partial compliance with 1 category, 0 compliance with the other 3. This is obvious. Let's get on with it. Yield back.
Gentleman yields back. Anyone seek? Mr. Bilbray is recognized for 1 minute.
Thank you, Mr. Chairman. Mr. Chairman, I don't need to lecture anybody on this committee about our responsibilities. I think Democrats and Republicans across the board know how important the oversight aspect is, and that we sit as the representatives of the stockholders in this great experiment we call the American experience. I think, so sadly, something the Founding Fathers never thought would happen is that when we look at oversight, because of the concept of party affiliation, rather than having a critical review of the executive branch by the oversight capabilities, we've had a built-in defense mechanism built in this oversight that the Founding Fathers did not intend. And I hope that both sides of the aisle really remind ourselves that we have one thing that Congress has not done in the past is actually demanded the executive branch recognize our co-equal status. It's always easier to take the path of least resistance. Doing the right thing, even if it's your own party that's sitting in the White House, is not only the right thing to do, it is the legal and moral thing to do because we swore to uphold that Constitution, and part of that is to take on our own guys, even or take on somebody when they may be wrong, or investigate and do the oversight, even if it may be one of our own party affiliation. And I yield back.
Ms. Schakowsky is recognized for 1 minute.
Thank you, Mr. Chairman. This is so disappointing.
My mother-in-law, Shelley, is unbelievable with Jake, and she treats me kind of nice, too. So it all works out.
So you're going into the delivery room with a girl's name, with no boy's name.
John likes Chase.
The chair calls up the resolution and asks the clerk to report.
A resolution.
I beg your pardon. Mr. Murphy is recognized for 1 minute.
Thank you, Mr. Chairman. I just want to say that $11 billion is not a molehill. And in terms of lack of cooperation, there is plenty of evidence of lack of cooperation when this committee asks for documents, and they're given partial documents, very selected emails that cover just 1 week. When there's questions about how the $11 billion was used by a company that then shuttered a plant and changed its stock offerings, there's enough questions behind to say what really happened. You cannot review the facts of loan guarantee without the information, and when you have refusals and delays, they're at best desultory and at worst deceptive with a purpose to hide information. So with that, I believe that we should be supporting this in a bipartisan way, just as this committee repeatedly supported requests when the other side had the majority.
Would the gentleman let me clarify? I don't think the money is the molehill. I think the way the action toward OMB, I think, has been.
I reclaim my time. I think that I appreciate that, but I understand what you mean by that. But I think that the mountain here is also that when the part of the executive branch or anything else is refusing to provide documents to a committee which has jurisdiction of an $11 billion issue that is important, I believe we should be supporting the subpoena. Thank you.
If there's no further opening statement, the chair calls up the resolution and asks the clerk to report.
A resolution offered by Mr. Burgess. Be it resolved by the Committee on Energy and Commerce that upon the adoption of this resolution, the chairman of the Committee on Energy and Commerce may authorize and issue a subpoena duces tecum to the Office of Management and Budget relating to or arising from the committee's investigation of the following matter. 1. A loan guarantee made to Solyndra Incorporated on September 2nd, 2009 by the Department of Energy. This resolution is adopted pursuant to Rule 11, Clause 2M1 and 3 of the Rules of the House of Representatives.
Thank you. The chair recognizes Dr. Burgess for 5 minutes in support of his resolution.
Thank you, Mr. Chairman. The resolution offered today, which authorizes Chairman Fred Upton of this committee to issue a subpoena to the Office of Management and the Budget for documents related to the Department of Energy loan guarantee made to Solyndra. This committee has a long tradition of conducting thorough and reasoned oversight on matters within our jurisdiction. Often what we've uncovered in these investigations has gone on to inform the committee's members on opinions on legislation that may be drafted. In this instance, the committee is conducting oversight of the Department of Energy Loan Guarantee Program. It's a relatively new program. It was created in the Energy Policy Act in 2005, but it did not begin to issue loan guarantees until 2009, when the stimulus bill provided $2.5 billion to pay the credit subsidy costs of the guarantees for the applicants. Since then, the program has ramped up significantly and has announced 20 projects with financing of over $11 billion. Despite the fact that this is a new program and making guarantees totaling in billions of dollars, this committee did not conduct any oversight of this program in the last Congress. Late last year, there were a number of reports describing the financial problems experienced by the first loan guarantee recipient, Solyndra. It only made sense that the committee look into this program and determine whether Department of Energy and Office of Management of the Budget were thoroughly vetting these deals and doing everything possible to mitigate the risk to the taxpayer. The committee learned that Office of Management of the Budget is charged with reviewing the credit subsidy costs of these loans, which are essentially a reflection of the risk of the loan. The committee also learned that in an October 2010 White House memorandum, President Obama's advisors had expressed some concerns about how the Department of Energy program was being administered, and in particular, the memorandum discussed the Office of Management of the Budget's role in the process. For these reasons, on March 14, 2011, the committee requested certain documents from OMB relating to the Solyndra deal, including the Office of Management of the Budget's internal reports and analyses of these communications. Since then, the committee staff has engaged in protracted negotiations with the Office of Management of the Budget to get the documents the committee requested so that it can learn what happened in the Solyndra deal, and also that this committee can carry out the legislative functions with respect to the Department of Energy's loan program. While the history of this committee's negotiations with OMB is long and complicated, the matter before this committee now, the resolution authorizing the subpoena, is really quite simple. Number one, the committee needs the information to determine exactly what DOE and OMB did as it weighed the Solyndra deal, and whether they did a thorough job of analyzing the risks presented. We have made this point repeatedly to the Office of Management and the Budget. Secondly, we have tried to find ways to accommodate OMB's concerns and obtain this information, but essentially to no avail. Thirdly, the Office of Management of the Budget continues to withhold the documents this committee has requested and has yet to assert a valid reason for withholding them. And fourthly, 120 days have passed since the committee asked for these documents. When Congressman Waxman was attempting to get similar documents from the Office of Management of the Budget in 2008, he was not nearly so patient. He sent a subpoena to the Office of Management of the Budget 1 month after he sent his original document request letter. It is time for this investigation to move forward. I hope the members of this committee will support the resolution and vote yes. This should not be political or partisan. When the Republicans were in the minority in the last 4 years, as I recall, we always supported the Democratic majority when it came to subpoenas. What this resolution is about is protecting the committee's right to know information that is relevant to our legislative functions. We should be protecting this institutional interest. I mentioned earlier in the statement that this committee has a strong investigative tradition. It also has a strong tradition of bipartisan support when it comes to issuing subpoenas, as committee members have recognized that failing to do so weakens this committee's constitutional powers. I urge my colleagues on both sides to support the resolution, and I'll yield back the balance of my time.
I thank the gentleman. Is there further discussion on the resolution? The ranking member, Ms. Deguette, is recognized.
Thank you very much, Mr. Chairman. The first thing I want to say, I just want to reiterate, everybody on this side of the aisle believes, and Mr. Bilbray, I want to address this specifically to what you said. Every single person on this side of the aisle thinks it is well within the purview of this committee to investigate this Solyndra deal and to see what happened here. And every single person supports appropriate document production. So I just want the record to be very clear on that. Nobody is trying to block any kind of investigation. The concern I've got is that I really do think that the OMB has been trying. We can argue about whether they've been trying hard enough or deep enough or long enough, and I think that that's a good discussion to have, but they have been trying to comply with what is admittedly a very broad document request. In the March 14, 2001 or 2011 letter to the director of the OMB, this committee requested all documents in possession of the OMB relating to the $535 million loan guarantee for Solyndra and the loan guarantee's credit subsidy cost, including but not limited to notes, analyses, reports, memoranda, and all drafts of such documents. Number two, all documents containing communications between and among Office of Management and Budget officials, staff, administrators, and employees relating to the $535 million loan guarantee for Solyndra, including but not limited to letters and email. And And at that point, OMB started trying to work with the committee to figure out exactly what those documents were and how they would be produced. And as I understand it, and I've been involved in some of those discussions on a member level as well, as I understand it, there have now been thousands of documents that have been produced both by DOE and OMB. Now, sometime after June 24th, these requests were apparently distilled down into these 4 specific requests that are in the July 13, 2011 memo. And it's my understanding that all of the documents relating to request number 1 have been produced in camera, and maybe not all of the rest of those documents, but it's also my understanding that OMB has expressed a willingness to identify what those documents are and to produce them. So I just think it's inaccurate to say that they haven't been trying to comply with this request. So you know, my recommendation would be bring them back in, see what they're going to do, and if they don't do it, then to subpoena the documents. That's been the grand tradition of this committee on a bipartisan basis, and that's all I'm suggesting.
I thank the gentlelady. Does the gentleman from California strike the requisite number of words?
Yes, I do.
Recognized for 5 minutes.
Mr. Chairman, we can talk about all the documents in the world. The fact that the redaction has occurred, and executive privilege has not been invoked for the executive branch deciding that there are things that the legislative branch does not have a right to see without declaring executive privilege over the item. So what is
Would the gentleman yield?
Yes.
I'm not sure subpoena fixes that problem.
I'm sorry, but it's still, I'm just saying, this is exactly the indication of the problem we have with, we need to assert right now that once this happens, and this is why I called on Republicans and Democrats, no matter who's in the White House, as the legislative body, that once you see that kind of action by the executive branch, Democrats and Republicans should join together and say, wait, you do not have a right to do this unless you're willing to cross the line and start claiming executive privilege. Because what they're saying, Madam Ranking Member, is that we have the right of knowledge and information that you don't have, and you get it only if we choose to give it to you. We have no obligation to give you that information. And they can do that carte blanche, not having to refer to executive privilege. That's where we have not, Democrats and Republicans together, have not executed our responsibility oversight with this
If the gentleman will yield, that's the issue of the redaction is not even what we're talking about today, because the subpoena is not even going to address that. So perhaps we should sit down and talk about the redacted documents and what their rationale was.
Reclaiming my time. The fact is, that is exactly the indicator of where the problem is. You may say about the symptoms about seeing all this other item, but when you're saying, what do you have there? What are you doing? We've already seen there's a conscious effort by somebody, and I don't think it goes to the top, but somebody in the executive branch that says, we're not going to give you the information and we don't have to. That's when the subpoena process is supposed to be triggered, and it should be triggered by both sides of the aisle all the time, regardless of who's in the White House. And I yield back.
Back. The gentleman from California, Mr. Waxman, is recognized for 5 minutes. Strike the requisite.
I do want to point out that the OMB has not said, we don't have to give you the information, and we're not going to give it to you. They have not said that. They said, tell us what, OMB, what you want, and we'll provide it to you. But what is this inquiry about? The inquiry is about whether the government has done an adequate job in deciding to give this credit subsidy review, this loan guarantees to Solyndra. And so what are the questions you would expect OMB to ask in evaluating whether the OMB did its job? The financial condition of the company, the structure of the loan, relevant external analyses such as independent financial assessments and engineering reports, and market analysis. Those are all things that we want OMB or DOE to ask about. And they gave our committee thousands of pages of documents. We've reviewed them from DOE and OMB, and they support the accounting OMB has given us that They did all of these issues. They reviewed all these questions. Now, I don't dispute for a minute this is a legitimate subject of review for our committee. And if the majority has a specific concern with the OMB review process, a logical way to proceed would be to identify those concerns and ask for information relevant to understanding those concerns. In other words, if you're trying to get information from somebody, they give you some information, you say, well, that's not enough, I want to know specifically about this. I'd like to know more about that. I want to get all the documents related to this point. Well, that isn't what we're dealing with now. The majority believes OMB is not, if the majority said the OMB didn't properly assess market analysis or the structure of the loan, that would certainly be a basis for further discussions. What we have now is the majority failing to make clear why it needs additional documents. Instead, they're insisting on a sweeping request for all internal OMB documents and communications with the White House. Now, without knowing what you're asking for or what you're looking for, you're asking for everything they have. Now, the problem with that, when you have a fishing expedition, an overexpanded request for information, is OMB has to decide what effect is that going to have on their employees if every email they have on every subject gets in the hands of a Republican-led committee that may be using this for partisan purposes. I'm not making the allegation, but they could imagine that easily enough. OMB has said that a lot of these companies that might come in for a loan guarantee, if the information were public about a loan guarantee they've already given, they can calculate how that loan guarantee was looked at and play a way to game the system so they could get that loan guarantee as well. So I think the point we're trying to make is if they've refused to give information that we need to have, we would all join you in demanding it and even in getting a subpoena. But OMB has not refused information. OMB has refused to turn over everything it has. And that is I don't know what a fishing expedition is if not something like that. If you want to know how OMB handled the evaluating the financial condition of the company, we got information on that, the structure of the loan, all these other things. If you think they didn't do something right, tell them, well, we have suspicions that you didn't look at the market analysis correctly. Give us all the information you have on the market analysis. We're not asking for specifics, we're asking for everything. I think there was a scene in...
Would the gentleman yield for a second? Are you saying...
Yeah.
I'm sorry.
Yeah.
Are you saying that in this process of trying to obtain documents regarding the evaluating the loan,
yeah,
that, for example, the request for emails and communications between DOE, OMB, and the White House are not proper? Is that what you're saying? If we eliminated that, you would support this? Because that's what I'm hearing.
No, what I'm saying
I yield back.
What I'm saying is that the request is for everything. The communications between these agencies, the emails that employees at OMB had in their files that might have something to do with this. It's very broad.
Yeah.
I don't object to asking about the White House communications or communications between OMB and DOE. What I think is there's a step or two to be taken before you have to get to a subpoena. They haven't said no to a request, except for a request. Turn over everything you have, and then we'll decide whether it's something we need or not. And that's an overly broad invasion of the information that's at OMB, and they feel it could jeopardize their doing their job with other requests for loans. So if it's a legitimate concern, I'm all for getting it. But if it's a broad sweep and they haven't said no, I think you have a further discussion. You come back and say, well, you haven't given me this, and this is why I think you ought to get that, and I want this specific thing. They haven't said no to any request like that.
Gentleman's time has expired. Who seeks recognition? The gentleman from Texas, Mr. Barton.
Thank you, Mr. Chairman. It comes a point we need to call the question, and let's have the vote and move on with it. But I do think a little bit of debate from our side may be in order, given what's just been said. In the last Congress, as the ranking member, the first subpoena request that Chairman Waxman asked was to compel attendance of a witness that didn't want to attend. I supported that subpoena request, and we knew that the witness, if he was compelled to attend, would plead his right against self-incrimination, which, as I recollect, he did. So when Chairman Dingell was the chairman and I was the ranking member, I do not, Mr. Dingell could correct me if I'm wrong, but I don't believe that we opposed any request for subpoenas during Chairman Dingell's tenure. And in Chairman Waxman's tenure, I think there were 2 times over 2 years that I lodged a protest against the subpoena request that Chairman Waxman or his or the subcommittee chairwoman, Ms. DeGette, offered. I want to refer the committee to the Congress when Chairman Waxman was chairman of the Oversight Committee back in 2008. He asked for documents from OMB. They were not forthcoming, and he initiated a subpoena request for those documents, very similar to this document request. And when that was not forthcoming, he threatened a contempt of Congress investigation, all within 3 months, back in 2008. He was on a different committee. He was the chairman of the Oversight Committee, and as chairman, he had the authority to issue the subpoena on his own judgment.
Will the gentleman yield?
I will at the appropriate time, not right, but I will before I conclude my remarks. So those cases seem very similar to me. In this case, it's not a broad fishing expedition. This is a program that was authorized by this committee in the Energy Policy Act of 2005. It's an $11 billion loan guarantee program. The particular company in question had received over $500 million in commitments of loan guarantees from the Department of Energy, $500 million. Because of apparent or alleged problems within the company, DOE or OMB or some combination of the two had grave questions about whether they should get additional funding. It is the proper oversight role of this committee and this subcommittee to get those documents. Now, the document request that's been issued is a document request that is a boilerplate standard document request that members on both sides of the aisle have perfected over the last 20 years. Chairman Dingell was the past master at document request, and when we became the majority, we basically took his language, and to my knowledge, it's the language that we're still using. It's very specific to a company, to a particular loan guarantee. It is not a fishing expedition. Members of both parties can quibble over the conclusions from reviewing the documents, but we shouldn't quibble that this committee and this subcommittee has the right to the documents. And again, after 4 months, one of the witnesses from OMB didn't even show up at a hearing. And in requests for emails, we got 8 for 1 week. The minority staff agreed to contact OMB, I'm told, and in the last 2 to 3 weeks, they've received nothing. Or if they've received it, they haven't shared it with the majority. So at what time does the Congress exercise its power under the Constitution to get information on which we can then disagree, but at least both sides have access to the information? And I think it's time to do it, Mr. Chairman, and I think the subpoena request is timely. Now, with that, I would yield to Mr. Waxman, as I said I would.
Well, I thank you for yielding, and I hope I can say what I have to say in less than 30 seconds. I don't disagree it's a proper oversight role to get documents. But in the case that you cited and I mentioned in my opening statement about our request to OMB, we had clear evidence that the Bush OMB was acting contrary to the Clean Air Act. Here, we have no evidence that anything has gone on. The Bush administration OMB did not cooperate with our committee. Here, we have OMB cooperating with the committee.
Your definition of cooperation is different than mine.
Well, the two circumstances are different. There's no evidence of OMB impropriety, and OMB has been attempting to meet the committee's needs. But rather than allow them to meet the committee's needs, we're issuing a subpoena. I guess the only pertinence of the two is that you want to say I'm hypocritical because I supported their case and not
said
Ned's
the
case.
cases.
But they are
I would
different
never say the
cases.
gentleman is hypocritical.
There are different
We have two
circumstances.
cases with the same agency.
And I think we
the
ought to
same
have a
general
very
time.
clear reason when you use a subpoena, because it is so drastic an action, that you have a reason for believing something wrong has happened, and you're not getting the information you're entitled to get, and you want to exhaust the attempts to get that information before a subpoena.
Reclaiming my lost time, it is not a requirement that you allege impropriety to request documents. If the only way to get a
How about alleging a reason for it?
is to say that there's an impropriety, then you'll never get very many documents. You get the documents and then to decide whether there's an impropriety.
The gentleman's time has expired. I call attention to the members. We have votes shortly. If there's no further discussion on the resolution, the vote occurs on the resolution. All those in favor shall signify by saying aye. Aye. All those opposed say no.
No.
The ayes have it, and the resolution. Request for a roll call vote. The gentlelady requests a roll call vote. The clerk will call the roll.
Mr. Terry. Aye. Mr. Terry, aye. Mr. Sullivan. Aye. Mr. Sullivan, aye. Mr. Murphy. Aye. Mr. Murphy, aye. Mr. Burgess. Aye. Mr. Burgess, aye. Mrs. Blackburn. Mrs. Blackburn, aye. Mrs. Myrick. Mrs. Myrick, aye. Mr. Bilbray. Mr. Bilbray, aye. Mr. Gingrey. Mr. Scalise. Mr. Scalise, aye. Mr. Gardner. Mr. Gardner, aye. Mr. Griffith. Mr. Griffith, aye. Mr. Barton. Mr. Barton, aye. Mr. Upton. Mr. Upton, aye. Ms. DeGette.
No.
Ms. DeGette, nay. Ms. Schakowsky. Mr. Ross. Ms. Castor. Ms. Castor, nay. Mr. Markey. Mr. Green. No. Mr. Green, nay. Ms. Christensen. Mr. Dingle.
No.
Mr. Dingle, nay. Mr. Waxman.
No.
Mr. Waxman, nay. Mr. Stearns.
Aye.
Mr.
Are there any
Stearns.
other members
Aye.
who wish to vote who have not voted?